All right, let me talk about Dred Scott a little bit and then move on to Slaughterhouse. But the background question behind Dred Scott, of course, let me just toss this out to you guys and just see what you think. And I'll be curious if you talk about this with your students, how you do is, to what is our Constitution a pro-slavery Constitution? Was it written as a pro-slavery or slavery-protecting Constitution? Do you guys talk about this with your kids? So what do you tell them? I mean, obviously, some people thought it was, some people thought it wasn't. But what do you tell them? Yeah, sure.
Well, I usually ask as a question and have them tell me. But I guess.
Of course, as with all people, that means you're just guiding them to say what you want.
By the time we reached the mid-1850s, I would say that increasingly, especially with this case, that the court and Southerners had great hopes that the Fifth Amendment property.
No, I mean the original Constitution.
Yeah.
In 1787.
I guess short answer for me would be yes, in protection of property rights. That there's even though the word isn't mentioned and all that, that there is a fundamental protection of property that most Southerners took comfort in.
Now, if you look at the Constitution, I think there's 6 clauses of the 84 that actually are clear references to slavery, although they never use the word. The 3 main ones, which are pretty explicit, are the 3/5 clause, so that for both taxation and representation. Now, of course, it doesn't follow that that's not slavery protecting, right? That's just recognition of a fact on the ground that there is slavery and a compromise as to how to count to those people. And it's really interesting the way over time people have changed in their interpretation of that clause. So there was a time when the 3/5 clause was thought to be an offense, right? Because it recognized some people as less than whole people. Then there was a time when it was thought to actually be better than not recognizing them at all, right? That is, say, it acknowledged that they should count in some notion of, then it's been condemned because it gave the South disproportionate power, and so on. So people have gone back and forth on how to think about the morality of the 3/5 clause in context. But as far as slavery protecting goes, I think it's neutral. It just acknowledges the fact that there is slavery and is a reasonable compromise borrowed from the Confederation period. So it was that they didn't debate the 3/5 clause because they'd already been using that during the Confederation period. Second clause is the clause saying that, I love this one, you cannot preclude the migration or importation of persons for 20 years, although you can tax at $10 a head. The reason it's interesting, if it was just migration, it wouldn't be a reference to slavery at all. It's that importation part. Because we don't import people, we import property, but so the only persons who could be imported were obviously slaves. Another compromise, that is slavery protecting, obviously, in a way. But, right, and it's striking that 20 years to the date, Congress barred the trade, but of course it didn't matter so much because by then the internal trade was sufficiently large that actually most of the Southern slaveholders liked that it's basically just a form of protectionism and limited competition so they could get more money on the domestic slave trade. And then third, of course, is the fugitive slave clause. So those are the 3 clauses that are most explicit. Then out of those, and in particular out of 3/5, some other clauses, implications follow. So for the abolitionists, anything that was short of affirmatively and aggressively eliminating slavery was pro-slavery. It was a pact with death and so on, pact with hell. I think, obviously the best way to characterize it is simply ambivalence. There's a range of views already. There is an abolition movement. It's relatively small at this time. And if you read the debates, especially the South Carolina representatives were as aggressive about the protection of slavery as anybody was in the 1840s or 50s. So that view was already out there as well. Most of the founders are obviously ambivalent. They're struggling with the moral consequences of what they said in the Declaration of Independence. They struggled with it when they wrote it. Right? In the first draft, Jefferson has a clause about slavery that the Congress takes out, and so on. Madison, in the course of the convention, has a note to himself in which during the debate over large states and small states, which always struck him correctly as bizarre. I mean, that's right, it's really interesting because Madison's point is, here, I'll do it, okay. Madison's point is, once the government's up and running, I can't think of interests that are going to divide along large state, small state lines, which is right. There's no interest that all the small states share, because New Jersey and, say, Georgia, their interests are determined by other things that have more to do with regional connections than anything else. So there was never a dispute in which the large states divided against the small states, because political interests just don't have anything to do with the size of the state.
I don't think it's on yet.
No, I haven't turned it on. So, and Madison says in a note, he says, it seems to me where the big problem's going to come is the division between the North and the South and the slaveholding states and the non-slaveholding states. And that's going to be a big problem as we look on down the line, but I don't know what to do about it. And so there was exactly that ambivalence. So the real question, I think, that's worth talking about with students is could they have done anything different than what they did? Say, right? Could they have, at that time, taken a more aggressive posture against slavery? You know, maybe not. It's actually hard to know. So would the southern states have walked?
Yes.
Maybe. You don't know for sure. You really don't know for sure. The consequences of not, think of what they did to North Carolina and Rhode Island for not ratifying. Both those states turned around and ratified very quickly because they realized that independently, they were completely lost. They had not a chance to survive as states, and they were either going to get absorbed by England or something like that. So the costs of stepping out of the Union were perceived to be, and rightly so, really high. So there might have been, again, I think probably not, and I'm not sure, South Carolina definitely would not have, but if it was just South Carolina, not clear what would have happened in some of the other southern states, and then what would have happened in South Carolina. So that you would have needed some kind of provision. Obviously, you couldn't have just abolished slavery, but there probably were an array of options out there for gradual emancipation, for emancipation with compensation. A lot of the plans that get talked about in the 19th century that might not have produced the slave states just walking out on the Constitution.
It's interesting being from the South and how I used to teach it and how it taught to me that slavery was in the 1860s, 1850s, and 40s. You have to think about slavery as a labor force, and the fact that these plantation owners, these farmers, needed the labor force to get the crops in and out of the fields. And that when Lincoln writes the first draft of the Emancipation Proclamation, he puts in there provisions to financially compensate the slave owners when the slaves are set free, because Lincoln himself realizes that it's more of an economical labor issue as much as it is a humanities issue. And that's one thing that I think that sometimes gets lost when we're talking about Dred Scott and the issue of slavery, and we look at it simply because slavery's bad. Yes, it is, but then the flip side is, well, look at it from a labor force economical viewpoint also.
Well, for the vast majority of Northerners, it's only an economical issue. That's all it is. Right? The Republican ideology, the free labor ideology, is what they're concerned with. It's competition, that they can't, I have to pay my workers and you don't have to pay yours, we're not in a fair position, and so on. So yes, and of course, no one would be, the consequence would be not that plantation owners would no longer have workers to work their fields, it would be that they'd have to pay them. So their own profits might go down some. And they'd face a little more competition. And of course, if you believe in free markets, then you would just get a more efficient system so that slavery is in fact just a distortion of the market that props up a lot of inefficient and economically undesirable activities, which is undoubtedly the case, right? That was undoubtedly the case for the South. So the South lagged in every single indicator over the North in economic growth prior to the Civil War, and there's no question that the slave system was a major part of that, right? With distributional effects that got a lot of wealth to a very small group, but that were disastrous for the region as a whole. Okay. In any event, like I said, I think when you teach this, obviously you have to start there and talk about it a little bit. Let me talk about something you probably don't, which is judicial review between Marbury and Dred Scott, because there is this conventional wisdom that the Supreme Court struck down Section 13 in Marbury and then didn't strike down another law until Dred Scott in 1856, which is not accurate. It's not accurate even as regards the Supreme Court, but it's really not accurate as regards judicial review in the American political and constitutional system. Okay, so first, there actually are some other, even federal laws that are struck down in between. They're small ones, and most of them are cases involving property transfers, which we'll talk about a little bit in connection with Lochner. But I'd say there are instances where legislatures take property from A and give it to B, and there are some federal land grants as well as state land grant programs, and courts strike those down through the period. So no major cases in the same way that Marbury or Dred Scott were major cases, but there are some federal statutes that are struck down in the period. More importantly, there are many ongoing controversies about the role of judicial review. So it's still a part of the discourse all through the period. McCulloch, in the period around 1816 to 1821, there's a huge amount of argument around first McCulloch and then a series of other cases, Combs v. Virginia. I don't know how many of these cases you know. They're not Martin v. Hunter's lessee, and so just a little group of cases because the Marshall Court is being very aggressive in interpreting the Constitution broadly. Now, these don't produce quite the same controversies because, of course, the ultimate response is for the Republicans who still control the political branches just not to act on that, right? So the fact that the court just interpreted the Constitution to give Congress all this power, we think that was wrong. We don't think we have to follow it. And then you've got other people saying, yes, you do. The court is supreme, blah, blah, blah. But it doesn't matter. We don't have to do anything. And so we just won't. There's a famous exchange where I think it's Spencer Rowan, one of the leading opponents of the court, writes Madison a letter in the early 1820s in despair. What do we do about this Marshall Court? Madison writes back saying, what we do is, of course they're wrong. What we do is make appeals to the people and just don't pass the laws. But so you have, and remember, this peaks around the time of Gibbons v. Ogden, which is 1824. So Gibbons v. Ogden is kind of the high watermark of the Marshall Court, where they read the Commerce Clause really broadly. It produces an enormous backlash. So in 1825 to 1827, there are a series of bills proposed in Congress to do everything from requiring the judges to issue multiple opinions, not just a single opinion for the court, to Senate oversight of judicial opinions and a 2/3 override in the Senate on any given case, and another slew. And of course, the response of the Marshall Court is to back off. So in cases decided after Gibbons, the court backs off on almost everything, which just enough so that none of the bills actually need to get passed. And that's what I'm talking about in terms of the politics of the way the justice's power ebbs and flows depending on political reactions. So the court retreats, and in fact, by the time Marshall passes away and Story retires, which is in the mid-1830s, they're both morosely depressed. You read their correspondence near the end. They're just really depressed because they realize they've lost. Right? The fight of their life was to protect, secure, expand the judicial power and a particular understanding of the Constitution, and now the Jacksonians are in full swing, and they have just gotten their butts kicked, and they've just lost completely, and they're very, very unhappy about it. I've already mentioned the Bank War, which was a high water moment in which judicial supremacy and judicial review are debated, and so on. More importantly and more interesting, what people often miss is especially in the 1840s and 50s, there was a huge upsurge in judicial review in the state courts. A lot of judicial activism in the state courts, and a lot of laws being struck down relative to what came before anyway, in that period. And why? Because remember what the Jacksonians came into power, and they of course they wanted popular control. They're the reason they called their party the Democracy, right? So they have a lot of issues on the agenda, but one of them is that we need to do something about the legal profession. Because here's an interesting development. I mentioned how the legal system in the 18th century and early 19th century was structured to secure popular control and jury control. The Federalists, having lost politically, just gotten demolished politically after 1800, and then even worse in the wake of the War of 1812, they basically disappear as a political party. But they don't disappear as a movement, and they shift into two domains. One is cultural, and the other is into the professional legal domain. And there's interesting books written on both these things if you're actually interested in. Let me focus on the legal domain. So what they do is they begin a very serious and thought out movement to secure professional control over the law, which involves a whole slew of things. So the first law schools come into being. There was one law school in Litchfield, Connecticut in the 1790s, but they found a whole bunch of law schools and fostered the idea of law as a science. So they write treatises. The first legal treatises are written in the 18 teens, all by Federalists. And what the treatises purport to do is show that the law is a science, that it requires a great deal of study to understand. That the common sense jurisprudence, which said just argue this stuff to the jury and let the common sense of 12 ordinary people figure it out, won't work because the law is a complicated science that you need to think about and understand. And therefore, only professionals should have control over it. And so as that takes hold, other developments unfold accordingly. Judges, it's no longer you can be a lay judge. You've got to be a professionally trained lawyer to be a judge. And the judge needs to have control over the law. And so over the course of about a 20 or 30-year period there, the judges take control of the law, although juries remain the fact finder, which is what they still are today. And then all the other devices are taken apart. Judges, especially appellate judges, no longer need to ride around. We want them to sit. They're published opinions. The whole system, the modern system of law begins to come into place. And along with all of this, of course, is a celebration of the common law. Right? Because the common law is the law that is made in and by courts, and especially now that the judges are doing it. So by the time you get into the high Jacksonian period, they realize this has happened, and there's a backlash. And the backlash takes two forms. One is we should have codification. We should displace the common law with statutory law made by the people's representatives, because a bunch of unelected judges or appointed judges or whatever, judges shouldn't be making the law. The people's representatives should. So that's one big response. It doesn't go very far. Codifying the common law turns out to be too difficult. The other, though, is, well, then we should make the judges elected. And so judicial elections come in big time initially as a way to re-seize control over the law. And as judges become elected and now have that source of authority, they begin to get more aggressive and powerful. So it's judicial elections in the states that actually produces, I think, the big upsurge in judicial activism in this period. A lot of judicial review that, although no one's thinking about the connection directly, has the consequence of legitimizing judicial review in a way that had really not been established in quite that same broad, pervasive way. And then it bleeds into the federal system in the wake of that. So now what happens in the late 1840s and in the early 1850s is people begin to think more about courts as places to go to resolve constitutional conflicts. And suddenly you have all these people saying, whoa, we are locked in a fight to the death over slavery in the territories. Let's send it over to the Supreme Court and have them decide it. It's a constitutional issue. It should be and can be decided by the court. They're noble and independent and all of this stuff. So there is this movement to actually have the courts resolve the issue of slavery in the territories, even though it is the most politically fraught issue on the stage all through the period. And of course, courts are centrally involved in all of the slavery disputes over the whole middle 19th century, right? The whole antebellum period. Mostly in the context of fugitive slaves, that's the most common one. And the Compromise of 1850 is designed because state courts in the North are so unhelpful in returning fugitive slaves. The Compromise of 1850 creates the first administrative agency, in effect, to get it out of courts. So we have these appointed executive officials who will rule in these cases. But there's another line of cases which you're maybe less aware of, which I'll just mention, which are part of this in the public perception, which is more like what's the issue in Dred Scott, which is it's a choice of law issue. So conflict of laws is a field of law. If you have an event or transaction that spans more than one state, whose law governs? If I'm standing in Illinois and I shoot you in Wisconsin, is it Wisconsin law or Illinois law that's going to decide my criminal liability? If I buy a car in Illinois that was manufactured in Michigan and drive to Arizona where I have an accident because of a defect in the car, whose law decides the tort liability and so on? So that's conflict of laws. And of course, it's a major issue with respect to slavery, in particular when people are moving around. So you have all these states where we don't acknowledge slavery. If somebody's here, they're free. So if I'm a Southerner who owns a slave and I take the slave with me into a free state, at what point can the free state declare the slave a free person? Right? And so courts developed this doctrine, the sojourn doctrine, where if I'm just passing through, they can't. If I stay for a certain amount of time, they can. But that's a matter of state law. And one of the issues, Dred Scott could have been very easily decided, because in theory, if Illinois law had applied, he had been in Illinois long enough that Dred Scott would have been freed under Illinois law. But the original trial was heard in Missouri, and Missouri applied its own law, where it didn't recognize that doctrine, and so he wasn't free under Missouri law. And the Supreme Court in an earlier case had held that in these cases, every state can apply its own law. So those are also very much a part of the public debate. So as I say, courts are very centrally involved. Prigg v. Pennsylvania is the only big Supreme Court case, although there are a bunch of other smaller cases in these choice of law contexts. Okay, yeah, question.
Were the majority of states electing their judges, or were there some states that were appointing? I just to get a sense of.
It's mixed, but a majority are electing. I think a pretty substantial majority. Again, it depends on where. So judicial election spreads over the late 1830s and 40s. I mean, today it's still the case. Most, I think, 42 states elect their judges in part or whole.
I was wondering about their qualifications when they're being elected, like how much are they supposed to know the Constitution? I mean, I know that the populace is supposed to help decide that, but.
Yeah, again, I don't want to take a position on whether judicial elections are a good or a bad thing. Well, everybody thinks they're a bad thing. They're definitely a bad thing today. But in the context of the mid-19th century, I think it's a very different system, and there's different arguments to be made. So whether they were bad in their origin or not, I think is a harder question. But what to me is interesting is an unintended consequence of judicial elections, which were meant to democratize the courts, was to increase the power of judicial review, and in particular to help legitimize it in the federal system where they weren't elected.
42 states have elected Supreme Court judges.
Well, actually, again, they're all different. Some are high courts, some are trial courts, some are both. Some have appointment first and then a retention election. Some have an election, and then there's a huge variation among the states in what they do. But I believe the number is still 42 have elections as some part of the judicial selection process. Okay, as I say, this movement that emerges to have the Supreme Court resolve the slavery in the territories issue, it's actually debated in the Compromise of 1850, but in the end there's not enough votes to explicitly make this an issue for the court to take. So notwithstanding that, I think largely because they had read their own press and believed it, the court reaches out to take Dred Scott with the idea that we'll settle the issue. All right, so let's just spend a couple minutes on Dred Scott. What's wrong with the opinion? Why is it a bad opinion?
He says it's bad.
Okay, do you want to defend it?
I would say that due to the time period that it was written,
I mean first as a legal matter.
as a legal matter,
Dred doesn't have standing in the court. They say that, yet they still talk more about.
Okay, so it's got there's two holdings in Dred Scott, right?
As you continue on with
So what are the two holdings?
He's not a citizen.
It's not a citizen.
What is he not being a citizen? That's not a holding. That's what's that relevant to? Not standing,
Jurisdiction.
jurisdiction, which is different than standing for what it's worth. And why? What's the basis on which Dred Scott seeks jurisdiction?
That he's a citizen of the state of Missouri.
Of Illinois.
Well, of somewhere
Well,
anyway.
that he's a citizen of the United States, bringing a case against a citizen of another state. Sandra.
Yes, right? So Article 3, remember the federal courts have limited jurisdiction. So the states have general jurisdiction. They can take jurisdiction over anything unless Congress has by legislation precluded it. Okay? Federal courts can only have jurisdiction as is granted by Congress. And Article 3, Section 2 limits Congress's power to grant jurisdiction to 9 heads of jurisdiction. Some of these are subject-oriented, like federal question jurisdiction, admiralty, and so on. Most of them, others, are citizenship-oriented. So Congress can give the federal court's jurisdiction over cases between citizens of different states, between citizens of a state and citizens of a foreign nation, and so on. So Dred Scott seeks jurisdiction under what's called the Diversity Clause, which is citizens of different states. That requires him to be a citizen of a state that's different from Sanford, who's Missouri. So the court says, with respect to that, what? Dred Scott,
It's not,
He's not a citizen.
nor is anybody a citizen who is a
African
color.
American.
right, that African Americans, not just slaves, right, African Americans
Were born.
are never citizens of the United States, can't be citizens of the United States. What's the second holding?
Missouri Compromise was unconstitutional.
Missouri Compromise.
Missouri Compromise is unconstitutional. Okay, and of course, it's the same problem as Marbury, right? Which is once you've said that they're not citizens and there's no jurisdiction, you have no business reaching out to decide the second question. So that's one problem, okay? But, so what?
Did they throw the whole Missouri Compromise out, or just that?
They threw the whole Missouri Compromise out, right? Okay. But that, you know, like, yeah. So the Missouri Compromise was dictum, all right? You know, that would not have brought the excoriation down that we've had, right, any more than it has in Marbury. So that can't be what's really wrong with the opinion. So what's really wrong with the opinion?
Is it the judiciary overruling the legislature? Is there-
Well, this is an instance of an exercise of judicial supremacy, and in the backlash that eventually happens, that becomes one of the issues. But again, are they wrong on the merits? Are they wrong on the merits?
Can you give us an article, the same one?
What's the basis for the holding that African Americans, that those of African descent cannot be citizens of the United States?
Well, I think he goes through this whole thing about historical review of the fact that they haven't been, but later on in some other part of the reading says that there were some states that indeed.
Right, well, that's okay. So on the state citizenship holding, right, the basis, it's an originalist argument. It's an originalist argument, but it's not an originalist interpretation of any clause in the Constitution. It's an originalist argument about what he asserts as a background assumption, which is no one in the founding generation would ever have thought that, you know, the people of African descent could be citizens of this country. I mean, come on, they were slaves, right? Blah, blah, blah. And Curtis takes him to task on this by noting that there were lots of free blacks, that the free blacks in the states voted, and so on. So it's this holding, which is based largely on history, fails largely because the history is downright embarrassing, and that's the only word for it. I mean, it's truly embarrassing, and it's embarrassing. I mean, it's not that his facts are completely wrong. It's that he ignores so many other facts that are inconsistent with them in order to draw a conclusion that taking those facts into account just wouldn't come close to following, okay? And how about what's wrong with the Missouri? So having said that, he doesn't stop there. Goes on to hold the Missouri Compromise unconstitutional. What's the basis for that, and what's wrong with it? And how does it violate the Fifth Amendment?
Doesn't allow citizens to bring their property into, if their property is slave, into certain parts of territories.
Yeah, right. So this is the first substantive, what we call, what subsequently came to be called substantive due process holding, right? That the federal government can't deprive someone of property this way. Now, not clear that that was wrong, as we'll talk about in a minute. That holding is actually less outrageous as a matter of law, certainly, than the first holding. It has now, in the post-Lochner era, come to be seen as outrageous. But what's interesting, the reason it has such political consequences is not just that the Missouri Compromise was struck down, because the truth is Republicans weren't terribly worried about it anyway because they didn't believe that slavery could or would thrive in any of these western states. But it's that the natural implication of that holding was not limited to the territories. Right? The way it's written in the argument has nothing to do with territories versus states. So the concern is, this is the first step, or really the fifth step now, in an ongoing process where soon we're going to be told that even in the northern free states, we can't keep slaveholders out with their slaves. Okay, now let me come back. But was Dred Scott wrong politically? So, right, Dred Scott, we're often told, what's the conventional wisdom on Dred Scott? Court decides this, there's a huge backlash, it's a cause of the Civil War, weakens the court for a generation, blah, blah, blah. Right? If that's all true, then yeah, Tony was obviously wrong politically. He made a stupid move.
Having grown up under judicial review in my lifetime, I can understand his desire to try to solve the issue once and for all. But, when I read Casey later and clearly Taney was taking the task by Rehnquist, I understood that's just silly. He thought he was going to settle it once and for all. And so for me, I see it as a poor decision.
Right, I mean, from his perspective, Finkelman, the excerpt you have from Finkelman is quite interesting, right? Where he says, look, you have to look at this from the perspective of, and Finkelman is not a fan of Dred Scott. You have to look at this from the perspective of Taney, though, where there had been, one progressive political compromise after another. This really seemed like the natural next flow. So after the Kansas-Nebraska Act and so on, it didn't seem implausible to go in this direction. But it did turn out, according to Finkelman, but it did turn out to be a total miscalculation. So it was still wrong politically, but we can understand Taney's perception. Right? Now, was it a cause of the Civil War?
No.
Anybody think it was a cause of the Civil War?
Contributing cause, sure.
Yeah. And so had the court gone the other way, do you think anything would have been different?
Some people could say, like, rip the Band-Aid off balloon and give you a chance, it gives you maybe an impetus to get to that point where we eventually had to get to anyhow, some people could say.
But as I say, imagine the court had ruled the other way. So they'd said, of course he's a citizen, and then rendered whatever ruling. Would that have had any different effect in terms of whether the war came about?
The war was inevitable. Is that what you're asking? Was it not inevitable?
Yeah, or was it, and even, I actually don't think this ruling was a significant contributing cause one way or the other, right? It seems that the reason the war is inevitable is because you can only go so far. Democratic government requires a degree of consensus to work. You can extend that degree of consensus in the way that you engineer your institutions. So it does, constitutions matter, right? You can have a system in which there is an adequate consensus to make it possible, but if you misengineer your institutions, it won't work. Flip side, if you have that kind of consensus and you engineer your institutions properly, you can make it work. And as tensions grow, you can make it work longer or better if you engineer your systems better. If you don't have the consensus, no engineering, though, is going to work. So I think arguably slavery had become the kind of issue over which there was just no longer any institutional engineering that would survive. What's interesting to note about the Civil War, I think, is the institutions that made it work were the parties, right? And indeed, the reason the country made it as long as it did was the Democratic Party in particular, which was a national political party and provided a basis for compromising within. And it's the breakup of the Democratic Party in 1860 over the issue of slavery that immediately leads to the Civil War. I mean, that's the most direct causal consequence, because now you no longer have any national institution that can resolve the political controversies, and so it's inevitable. The question would be, to what extent is Dred Scott a contributor to those political tensions? There, I think, had the court done nothing, it would have happened probably a little later. Had the court done the opposite of what it did, though, usually the way the debate is framed is, had Taney just been a better judge? Had he decided the case more intelligently on the law? Had he written a better legal opinion, in which case he would have had to reach the opposite result? Then it would have been better. And I think that is completely wrong. It just would have flipped who liked and who hated what the court had done.
I was just going to say that the reading, the part of Finkelman is like sort of articulates the way that I've learned and taught this particular part of U.S. history, where the Dred Scott, I think you're right, on either way that it was decided, it would have been used to galvanize the base of support either in favor of or against slavery in the territories, because that was, as I understand it, and as Finkelman talks about it, sort of the major issue that Lincoln used to then stand on in his platform for 1860. That's really the election of 1860 is where the lines along the North and the South, because of the breakup of the Democratic Party, actually leads to war.
Right. Well, of course, one issue, and I want to come back to that in one sec.
The lasting effect of Taney in what we're talking about is not did it lead to the Civil War. I think the more important question is, did it lead to the creation of the Republican Party? Because after...
Well, not the creation of the Republican Party is already there.
Well,
but
the ability to move it to a national, more prominent level.
Yeah.
I think after this decision, the next big election is 1960. 1860. And then you have Lincoln coming on board, you have the Democrat Party, as you said, divided into Northern Democrat and Southern Democrat.
So let me put both those comments together and just note one thing. There's a really interesting book that's been published in the last couple of years by Mark Graber. It's called like Dred Scott and the Problem of Constitutional Evil. It's worth reading. So Graber makes two arguments in the book, one of which is not very persuasive to me, which is he makes the argument that in context, Taney's legal arguments are better than, and arguably even correct. It's not very persuasive. He's not a lawyer, so. But the other argument he makes, because he is a political scientist, is actually pretty interesting, which is he looks at a more molecular level at the way Dred Scott played out. He says what Taney was trying to do was settle political tensions. He believed that in context this was actually a bit of a compromise, and he was right. And the sign of that is the following, which is the decision comes down in 1856, immediately after the presidential election. The politics surrounding slavery in the territories does diminish for the next little period, and in fact the Democrats make gains in the 1858 midterm election. So Dred Scott is working in exactly, along with all the other stuff, in the way that Taney wanted. So what changes it is Lecompton, right? And Lecompton is seen as a total betrayal by everyone in the North of any possibility that this is really any sort of compromise, right? Lecompton is seen as even when we win in the sense that there's supposed to be a free and fair choice, they're going to cheat. And they're going to get support for their cheating by all the slaveholders. And at that point, people go back and reread Dred Scott as part of basically unfair politics, and it becomes a cause célèbre in connection with all of this. It's actually very similar. Interestingly enough, there's a big debate about Brown. Did Brown versus the Board of Education have any effect? And Jerry Rosenberg wrote this book called The Hollow Hope, which very interestingly argues that Brown itself had no effect. It was not really a very important decision. It didn't do anything. It wasn't really a major motivator. Until the civil rights movement, which is motivated by something having nothing to do with Brown, comes along, and then it gets absorbed as part of it and gains a lot of momentum. So it's a very similar story here, which is Dred Scott, to the extent is not that significant, to the extent that it's doing anything, it's actually working, until Lecompton comes along, and then people look back at Dred Scott and see it in a different light and turn it into something else. And of course, I think that's a really important point, especially in understanding the way judicial decisions, when they play out, will play out, right? So it's part of a whole slew of political debates and political actions and activities around the issue of slavery and slavery in the territories that can be looked at one way or the other. And the interesting question then you want to ask is, if Lecompton hadn't happened, would the Civil War have happened, right? If in fact popular sovereignty had played out so that because there's a very large majority of non-slaveholders who voted for a non-slaveholding constitution in Kansas, if that had then happened, what would have happened?